friends, this is me, Cleta Laurencio, and today's topic, what I'm going to talk about is Muhammad Muslim versus State of Uttar Pradesh, where Supreme Court acquits father and son due in a 27-year-old murder case by according benefit of doubt. Now, the facts of the case, the land dispute between the accused and the victim, where Mr. Altaf Hussain allegedly had a certain land disputes with Muhammad Muslim and Shamshed. So, Mr. Altaf Hussain was going on a bicycle along with his son and nephew, where appellant, in range of enmity, assaulted him with towel and axe, and he died when two persons came and tried to get hold of appellant, but later when he escaped to jungle, leaving behind the blanket and cycle at the place of incident. Now, on 25th April 1995, a check of first information report FIR was registered. Further, it was being which was sent to the court after a delay of 4 days. The investigating officer, though allegedly recovered the cycle and the blanket from the appellant from place of the incident, but this evidence were never produced before the court. Now, during the trial, the appellant denied their involvement in the crime while submitting that no such incident took place and they were being false incident which has been taken place. On 25th April 1998, in Sessions Court convicted the appellant under Section 302 of IPC for committing murder of Altaf Hussain, that is the victim. The appellant were sentenced to life imprisonment along with fine of Rs 20,000 each in default of payment of fine. They have been ordered to undergo further 6 months of rigorous imprisonment. On 10th of September 2010, the High Court upheld the conviction sentence. Consequently, in 2011, appellant filed an appeal before the Supreme Court challenging their conviction. The appeal suit abated against the appellant on number 2 on 16th of August 2021. Then the appeal which came to the Supreme Court's verdict. So where the bench took over the view that the behavior of the deceased and the son's nephew appeared to be unnatural, where actually they had to save the deceased. So where they said totality of the facts and circumstances, especially unnatural behavior and conducting of the son and nephew deceased Altif, and timing the FIR and blanket and the cycle alleged to be that the accused appellant left behind at the incident were not produced before the court compels us to doubt the presence in the son and nephew deceased Altaf Hussain at the scene. Thus, the absence of any credible eyewitness to the incident and the fact the presence of the accused appellant presence incident were not well established are constrained to accord the benefit of doubt to both the accused and the appellant. Even if we ignore certain other minor dispensaries in the oral evidence, the delay in conducting the postmortem, the difference in the name of the weapons of crimes, that is double and pakadi, which are more or less similar type of instruments of cutting crops, etc. It is a case where the prosecution has miserably failed to prove the accused and appellant have committed the offense beyond a reasonable doubt. Now, it has been observed that the prosecution failed to prove the guilt and the accused were involvement in the assault and death of Altif Asam. So therefore, the acquittal has been granted based on benefit of doubt and the failure of prosecution to prove the appellant have committed the offense beyond any reasonable doubt. Thank you, and please do like and subscribe to my video. Thanks very much.